this morning's docket. Case number 105504, State v. Overman.
May it please the court, John Groovy for the appellant, Larry Overman. I'd like to reserve 3 minutes for rebuttal, please.
3 minutes is granted.
This case revolves around a car stop that was initiated for a suspended driver's license. After they made the stop, drugs were found. The drugs were admittedly my client's. He was then placed under arrest. Originally, he was placed under arrest for the suspended driver's license. His companion in the car was also detained, although they told her she was not under arrest. She was put in handcuffs after they gathered evidence, which included the finding of the drugs. The law enforcement officers decided to search the vehicle. When they conducted the search, neither Mr. Overman nor his companion in the vehicle were in the present area of the search, which is in violation of the statute at the time that controls the search, which would require them to be in the immediate presence in order to complete a search incident to arrest. Upon finding in the search, they did find evidence of other drug crimes. At the motion to suppress the discovery of these other crimes, basically the officers held we relied on the statute. They didn't come out and explicitly say they relied on the statute, but they said we were searching incident to an arrest for the crime of possession.
Does that preclude us from considering whether this would fit within the probable cause exigent circumstances, the automobile exception? Wasn't that argument made at the district court and made on appeal that exception applies also?
It was the district court reached the exigent circumstance. It really was never presented that way. It was always presented as we made an arrest for a drug-related crime and we searched incident to arrest pursuant to the statute.
I guess, okay, and you're saying the law enforcement officers never testified that they felt they had probable cause based on, they had information about syringes being in the car. They had the pouch with the marijuana and the meth in it, and coffee filters in the pocket. You know,
Right.
There were all number of things that might well have legitimately led a trained law enforcement officer to have probable cause that the vehicle contained fruits of a crime or evidence of a crime, wasn't there?
Yes, and they did rely on that, and there was evidence that there was probable cause.
And if we can get to that, do we need to spend a lot of time talking about the incident to the arrest? Because I don't see your defense against the automobile exception.
Well, in order for the automobile exception to apply, if there's probable cause, if there's an exigent circumstance, they'll be able to search the car without a search warrant. But in order to reach that exception, there has to be an exigent circumstance. And the exigent circumstance standard that this court has held before requires a law enforcement officer to reasonably believe there's a threat of imminent loss, destruction, removal, or concealment of evidence or contraband. And in this case, none of the officers who testified conveyed that feeling. They continue.
I think you're reading too much into that. I'm trying to find here I think it was my case, Santo Bella or something like that.
Yes, Sanchez Laredo.
Yeah, and basically said that if you've got an automobile that's mobile, then you've got the circumstances. You've got the exigent circumstances.
And here you had an unarrested companion, right? So she was in cuffs temporarily, but then she was let go. Is that right?
I assume she was let go.
Yeah. I'm just, and plus you judge these situations from kind of what the reasonable officer, right, would do in the circumstances or believe. Do you have to have an actual expressed subjective belief on the part of the officers executing these searches that there was an exigent circumstance? Do you need direct testimony on that to meet the exception?
I don't think there is here.
I know you say there isn't any. Do we need it?
I think that you do. I think you have to have some evidence that a reasonable officer would believe that that circumstance would exist that would present an exigent circumstance.
But it isn't. My problem with that is that it isn't a subjective determination. I mean, the officers, if they testified, they felt like they had probable cause. That wouldn't really mean much to us. If the issue was teed up, we would look at the facts to see if there's substantial competent evidence, and then we look at those facts de novo ourselves and determine if that would provide probable cause.
And I do think that it would provide probable cause in this situation. However, I do think there needs to be a finding that there is an exigent circumstance in this case, because what we have here is the officers continually said we're searching incident to arrest, and the district court found, well, an exception applies. This was an exigent circumstance. The vehicle was mobile because it could have been driven.
Exactly what we said in Sanchez Laredo, quote, no separate exigency requirement beyond a showing of mobility of the vehicle, end quote. That's all that was necessary.
Correct. And I also think requiring a finding of exigency in this case is a little bit different than the Sanchez Laredo case, because the Sanchez Laredo case focused on a purely United States constitutional challenge, whereas in this case we have United States constitutional challenge and a Kansas constitutional challenge. And where the line of federal cases is basically, if you have a car, it's therefore mobile so long as it's operable. Several states have actually come out, and when it's challenged on a state constitutional basis, that you actually need to have that separate finding of exigent circumstances, and we just don't have that here. And I think that in Sanchez Laredo, if the facts were similar to Sanchez Laredo in the sense that they were solely on a United States constitutional challenge, I think it would match up, and we would be.
Have we ever said that Kansas takes a different view?
A different view
Under our state constitution of what's required on that particular exception?
To my knowledge, you have not explicitly said anything that would be in line with what you're saying. However, the fact that we do have that reasonable officer standard to determine whether there's an exigent circumstance. And when we look at this situation and look at the officer's testimony, the officers clearly don't believe that this is an exigent circumstance. They clearly believe we have two people there. One is in custody under arrest. The other one's in handcuffs surrounded by two other officers. We're going to now go search this car incident to arrest. We're not searching the car because, well, if we don't search this car quickly, she's going to leave and there is a chance that she leaves with the evidence of a meth lab. That was never conveyed by the officers at any point at the district court level.
Any further questions? Any further presentation?
I'd like for you to move to the multiplicity question.
On multiplicity, we would, because the red phosphorus and the iodine would be covered in the drug paraphernalia statute, we believe that these are multiplicitous, that the red phosphorus and the iodine are
Well, I
drug
don't think there's any
paraphernalia.
question that they are defined as drug paraphernalia. I don't think there's any question that they overlap. We just have the case law here, Schoonover and then Thompson, that tried to explain the difference between the Kansas same elements rule for sentencing purposes and the Schoonover same elements test for multiplicity. And my understanding is that the distinction is that the same elements test for most multiplicity is simply a legislative interpretation tool, but that even if they are the same elements, if we divine that the legislature intended to make two offenses, then the legislature gets to decide what the constitutional double jeopardy means. That's okay. It's not double jeopardy if the legislature intended to create two offenses, even if they are overlapping elements. So tell me why that's wrong.
We're arguing the fact that because these are covered under the drug paraphernalia statute, that there should, and the Court of Appeals actually, there was the issue of sentencing on the severity level 2 to severity level 4 issue, and I think that is a little bit applicable here as well in this type of analysis. But the fact that it's codified in another statute that has a lower severity level crime, you would be sentenced on the lower severity level crime. I think the same sort of reasoning applies to the fact that because it's covered under the paraphernalia statute, and although it's also codified in a different statute, that they are basically covering the same issue and therefore multiplicitous.
But we have, I can't remember, maybe it was Fanning or one of our cases said one's a challenge to the conviction, the other's a challenge to sentencing, so we can use that distinction to justify having different tests. That same elements get you a win in the sentencing arena, but not necessarily in the conviction arena. I think it was Fanning that said that they're different inquiries, so they're different tests.
And I understand, and we believe that these are multiplicitous and these are the same. And I do understand that there is several negative holdings against.
Our problem is that the word offense is in the double jeopardy prohibition rather than conduct. So we have the same conduct,
Right.
resulting in two convictions, but they're also two offenses, and we have a statute that says the same conduct can give rise to more than one conviction.
Correct.
So how do we get around that?
I think that we have to continue to get around it through the fact that these are the fact that the red phosphorus and the iodine are essentially drug paraphernalia, and that's what they were classified as by the legislature. And I think that they getting two convictions from the same offense would make it multiplicitous.
So to distinguish in Schoonover, it was ephedrine and pseudoephedrine.
Correct.
Which were also defined as drug paraphernalia, correct?
Right.
And Schoonover says those weren't multiplicitous. So just because we changed the substance from ephedrine to red iodine, how does that change the result?
Just the fact that it's still the fact that it is a substance that was used to manufacture.
Okay, let me rephrase
I'm
that.
not sure I'm answering
How
your
can we
question.
give you relief without overruling Schoonover?
I'm not positive that you can. And finding that these are multiple, just because the fact that we're finding that they were codified in 2 places. So yes, I think that would be, we'd argue that was wrongly decided in our case, and that these would be multiplicitous.
Any more questions? Any further presentation?
Not this time.
Thank you, counsel.
May it please the court, the state appears by Assistant Solicitor General Valerie Chalmers. In Mr. Overman's petition for review, he did not actually take up issue of the Court of Appeals' alternative finding that there was probable cause plus exigent circumstances. So I would argue that that holding stands regardless of anything about the statute, and the court should be affirmed, the Court of Appeals should be affirmed in its entirety.
So you're saying the petition for review did not challenge the Court of Appeals ruling on probable cause? Did they make a ruling on probable cause?
They did an alternative ruling saying that even if this was a violation of the statute, there would be probable cause plus exigent circumstance in this case, and they listed some of the factors that they found supported probable cause. And I think in answer to Justice Johnston's previous question, is the exigent circumstances rule is clearly satisfied here. It's a mobile vehicle. I forget her name, Carrie.
Did you raise it in the Court of Appeals?
I did raise it in the Court of Appeals. I used the trial court as right for any reason.
And why was it properly raised there if the officers never testified that they relied on probable cause?
Because it's not a subjective officer standard, it's a reasonable officer standard, and here the reasonable officer would conclude that there was probable cause plus exigent circumstances based on the evidence that was presented at the suppression hearing. If there are no further questions, the state would just respectfully ask that you affirm the Court of Appeals in this case.
Go ahead.
Go ahead.
Just as a point of clarification, was there any argument made to the trial court about the probable cause plus exigent circumstances? You said that the officers did not testify that that was their basis.
I know in my brief, all I remember writing was that the district court didn't reach that ground. I don't remember if it was argued or not. I don't think it was, though. I think I argued it for the first time on the Court of Appeals.
All right, thank you. Justice Johnson, you had a question?
On the multiplicity, I think we have case law that says a lesser included offense is multiplicitous, don't we? I mean, we've got Schoonover, we've already talked about that, but if you have a lesser included offense, I think that's multiplicitous.
Yes.
My problem when we've got these overlapping elements like this, and we've said, for instance, you have to prove ephedrine, you don't have to, and in the other crime, you just have to prove any drug paraphernalia, so that there's 2 different areas of proof. But for a lesser included offense, if all the elements of one or some of the elements of the other, I don't understand if here we've got the red iodine or the iodine or red phosphorus. Why those aren't elements of the crime of possession of drug paraphernalia when the definition says that they are. And why wouldn't that be a lesser included offense of the possession of drug paraphernalia under that definition? That the elements of possession of iodine would be an element of possession of drug paraphernalia?
Well, I think the instruction would be possession of red phosphorus or iodine. The reasonable jury wouldn't go below that. They would say, yes, red phosphorus, iodine, so yes, check, that's drug paraphernalia. They wouldn't go down to the lower to figure out, oh, well, it's paraphernalia because it's red iodine. If they found it's red iodine and phosphorus,
But both crimes require with intent to use to manufacture.
Correct.
And of course, it's a little circular. The any material used to manufacture is a drug paraphernalia, right? Under the definition.
Mm-hmm.
So I don't understand. I don't understand why those aren't elements of the crime of drug paraphernalia. Because you would prove that it was used in material used to manufacture methamphetamine.
Yes. The only thing that would be different is that we are proving a specific drug paraphernalia work, which is no longer drug paraphernalia, but under the statute at the time, red phosphorus and iodine, you have to prove those. There would be no lesser included offense instruction given in this case, because if we proved red phosphorus and iodine, they wouldn't have to go any further, or at least if it was given, the jury would never
you
reach it.
proved possession of drug paraphernalia if you proved those.
Yeah, we automatically prove.
Yeah. Okay, thank you.
Thank you.
Any more questions? Thank you, counsel. You reserve 3 minutes for rebuttal.
The only thing that I wish to add is when counsel talked the reasonable standard of whether an exigent circumstance might exist. Just to reiterate, even at a reasonable officer standard, there was just no evidence presented that here in the situation that they believed that, and there was no exigent circumstance that would lead to the probable cause and exigent circumstance exception.
Any more questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.